What if I told you a sitting U.S. president could lose his golf courses, estates, and crown jewel properties? Not someday, not hypothetically, but right now. What if I told you a judge didn't just find him, but effectively said, pay up or we take it all? This isn't a rumor. This isn't cable news hype. This is a courtroom reality unfolding in real time for Donald Trump. For decades, Trump built a brand around being untouchably rich, billions in wealth, total dominance, always winning. But when a judge finally looked behind the curtain, the story collapsed. Financial records, valuations, hard evidence, and suddenly the man who claimed unlimited wealth couldn't prove he had it when it mattered most. That contradiction changed everything because now this isn't about politics. It's about fraud, money, and consequences. Judges are shutting him down. Appeals are failing. Legal gears are already turning. And by the end of this video, you'll understand exactly why the court destroyed his claims and why his reaction exposes the truth he's tried to hide for years. If this story made you pause, drop a comment and tell us, do you think you'll actually come up with the money or lose the properties? We read every single one. We put serious time and effort into breaking these stories down so you get facts, not spin. And that only works with your support. Subscribe to the channel right now. It's one click and it helps us keep bringing you the stories others won't explain this clearly. Here's the first and most important reason the judge destroyed Trump's claims. This case was never about opinions, politics, or interpretations. It was about documents, thousands of pages of them, financial statements, internal records, valuations sent to banks and insurers. And when Judge Arthur Engoron reviewed that evidence, he didn't see confusion or gray areas. He saw clear, repeated misrepresentation by Donald Trump and his business. Trump's defense tried to frame everything as normal real estate estimating, basically arguing that property values are subjective and everyone does it. That argument collapsed instantly under scrutiny. Why? Because these weren't casual guesses. These were certified financial statements used to secure loans, lower interest rates, and obtain insurance benefits. The numbers weren't just optimistic. They were wildly inflated, sometimes by hundreds of millions of dollars, and they were signed off as accurate. That's not puffery. That's a paper trail. What made this devastating for Trump is that the judge didn't need to rely on witness credibility or political arguments. The math spoke for itself. Properties were valued one way for banks and a completely different way for tax authorities. Sometimes in the very same year, same buildings, same land, two opposite values depending on what benefited Trump most at the time. Judges don't ignore patterns like that, especially when they repeat year after year. This is why the court didn't hesitate. Once fraud is proven through documentation, intent no longer needs guessing. The evidence showed consistency, planning, and advantage. That's why the ruling was so firm, so blunt, and so damaging. Trump wasn't undone by enemies or politics. He was undone by his own paperwork. Pause for a second and comment below. Do you think this case would have gone differently if those documents didn't exist? Or was this outcome inevitable? We spend hours breaking down complex legal cases into clear, honest explanations, so you don't have to rely on headlines or spin. If you value that effort, subscribe to the channel right now. It's one click and it helps us keep doing this work. The second reason the judge completely rejected Trump's defense is simple but devastating. This wasn't a one-time error or a misunderstood accounting decision. The court found repeated acts of fraud over many years across multiple properties, involving the same tactics again and again. And in the eyes of the law, patterns matter far more than excuses. Trump's legal team tried to argue that even if some numbers were off, they were isolated incidents, the kind of thing that happens in complex real estate empires. But Judge Arthur Engoron made it clear that this explanation didn't survive basic scrutiny. When the same behavior shows up year after year across financial statements, loan applications, and insurance filings, it stops looking like confusion and starts looking like strategy. You don't accidentally repeat the same mistake for a decade. What made this especially damaging is that the fraud wasn't confined to a single property or a single deal. The court identified multiple assets, multiple lenders, and multiple situations where values were inflated when Trump needed favorable terms and deflated when it came time to pay taxes or fees. That repetition is crucial. In civil fraud cases, judges don't just ask what happened once. They ask whether the behavior shows intent and benefit. And here, both were undeniable. This is why Trump's reaction has been so frantic. A single error can be explained away. A long gunning pattern can't tee. The moment the court labeled this conduct as systemic, the entire defense strategy collapsed. The judge didn't have to speculate about Trump's mindset. The consistency of the behavior did that for him. And once fraud becomes a habit, not a fluke, the penalties escalate fast. That's exactly what happened here, and it's why this ruling hit Trump so hard. Let us know in the comments. At what point does a mistake stop being a mistake and start being fraud? One time or 10 years in a row, we put real effort into connecting the legal dots so you can see the full picture, not just sound bites. If that matters to you, subscribe right now. It's one click, and it keeps this channel going. The third reason this case collapsed for Trump is one of the clearest signs of fraud you can possibly have. The same property was given two completely different values depending on what benefited him most at the moment. When Trump needed loans, better interest rates, or insurance advantages, properties suddenly became worth hundreds of millions more. But when it was time to pay taxes, those very same properties mysteriously shrank in value. Same land, same buildings, same year, totally different numbers. Judge Arthur Engoron made it clear that this wasn't clever business. It was deception. Trump's lawyers tried to argue that real estate valuation is subjective and that estimates can vary. That argument only works if the differences are reasonable. What the court saw instead were extreme swings, often without any legitimate explanation. These weren't small adjustments based on market changes. These were massive intentional shifts designed to extract maximum benefit in every situation. And here's why that matters. Legally, banks and insurers rely on these financial statements to make real decisions. How much to lend, what risks they're taking, what terms to offer. When those decisions are based on false information, the integrity of the entire system is compromised. And that's why the judge didn't accept the everyone does a defense because everyone doesn't do this. Most businesses don't tell one version of the truth to banks and another to tax authorities. That's not aggressive accounting. That's playing both sides of reality. This contradiction was devastating because it required no interpretation. The judge didn't need opinions, witnesses, or political context. The documents contradicted each other on their face. And when your own records can agree on what your property is worth, the court isn't going to give you the benefit of the doubt. That inconsistency alone was enough to shatter Trump's credibility. Think about this and tell us in the comments. Can the same property honestly be worth everything and worth much less at the same time? We break these cases down carefully because details matter and most coverage skips right past them. If you appreciate that effort, subscribe to the channel. It's one click and it helps us keep doing this work. One of Trump's loudest talking points throughout this case was simple. No one was harmed. His lawyers argued that the banks got paid back, the loans didn't default, and therefore there were no real victims. On the surface, that might sound convincing, but in a courtroom, it falls apart instantly. Judge Arthur Engoron made it clear that this argument shows a fundamental misunderstanding of how fraud works. Fraud isn't defined by whether someone lost money in the end. It's defined by whether decisions were made based on false information. Banks don't just hand out loans for fun. They calculate risk, interest rates, and terms using the financial data they're given. When that data is false, every decision that follows is tainted. The fact that Trump paid loans back doesn't erase the fact that he allegedly secured better deals than he would have otherwise received. That advantage alone is enough to establish fraud under New York law. To make this crystal clear, think of it this way. If someone lies on a mortgage application but still makes every payment, did they commit fraud? The answer is yes, because the lender relied on false statements to approve the loan. That's exactly how the court viewed Trump's conduct. Judge Ingram wasn't interested in whether the bank survived the transaction. He focused on whether they were misled at the start, and the documents showed they were. This is why the judge rejected Trump's argument so bluntly. Allowing a no-harm, no-foul defense would effectively legalize lying as long as you're rich enough to clean up the mess later. The court made it clear that the law doesn't work that way. Fraud is about truth, trust, and transparency, not just final outcomes. And once that principle was established, Trump's defense collapsed under its own logic. Drop a comment and tell us what you think. Should lying be allowed as long as the bill gets paid in the end? We put real effort into explaining why the law works the way it does, not just what happened. If that clarity matters to you, subscribe with one click. It helps us keep making these deep dive videos. Another major reason Trump's arguments collapsed is something many people still misunderstand. This was not a criminal case. It was a civil fraud case, and that distinction changed everything. Trump's usual playbook, delay immunity claims. Constitutional arguments simply didn't work here. Judge. Arthur Engerman made it clear from the start that the court was focused on money, accountability, and enforcement, not jail time or political status. In criminal cases, defendants can sometimes argue about intent, constitutional protections, or executive authority. In civil cases, especially fraud cases brought by a state, the question is much simpler. Did you lie? And did you benefit from it? If the answer is yes, penalties follow. There is no presidential shield against civil liability, no special exemption because someone holds office, and absolutely no rule that says powerful people get softer treatment when money is involved. Trump's legal team clearly understood how dangerous this was, which is why they repeatedly tried to frame the case as political persecution. But that framing didn't matter in a civil courtroom. Judge Enron wasn't ruling on speeches, tweets, or political behavior. He was ruling on financial statements and business conduct. And civil courts don't pause enforcement just because a defendant is famous, wealthy, or politically influential. This is what made the ruling so jarring for Trump and his supporters. There was no dramatic criminal verdict, no jury spectacle, just a judge calmly applying long-established civil law. The result was devastating precisely because it was routine. The court treated Trump the same way it would treat any business owner accused of inflating assets for personal gain. No immunity, no delay, no escape hatch. Once that reality set in, the outcome was almost inevitable. Civil law doesn't care about power, it cares about proof. Be honest in the comments. Should anyone, president or not, be immune from civil accountability? We put serious time into explaining the legal mechanics behind these cases, not just the headlines. If that effort matters to you, subscribe right now. One click helps us keep this channel alive. One of the most misleading claims Trump pushed after the ruling was that the $454 million judgment was some kind of outrageous punishment meant to humiliate him. But the court made it clear this number wasn't emotional, political, or random. It was mathematical. Judge Arthur Engerman based the penalty on how much Trump financially benefited from the fraud over time. In simple terms, the court said, you don't get to keep money gained through deception. Civil fraud penalties aren't tart about revenge. They're about discouragement, a legal concept that means forcing someone to give back profits they should never have earned in the first place. The judge looked at favorable loan terms, lower interest rates, insurance savings, and business advantages Trump received because banks believed he was wealthier than he actually was. When all of that was added up across years, the number became massive, not because the court wanted it to be, but because the advantage was massive. This is why Trump's argument that the fine was excessive went nowhere. Courts aren't required to make fraud affordable. If the gains are large, the repayment will be large. The law isn't designed to say, well, that's too much money for you, so we'll lower it. It's designed to say, return what you took. And the more sophisticated and long-running the scheme, the higher that number climbs. What made this especially damaging is that the penalty directly contradicted Trump's public image. If he truly had the wealth he claimed for decades, paying back money gained through fraud shouldn't have been insurmountable. The fact that it was framed that way by his own lawyers only reinforced the judge's conclusion. The inflated values weren't just misleading, they were essential to Trump's financial narrative. And once that narrative collapsed, the math did the rest. Comment below. Should fraud penalties hurt, or should they be easy to absorb if you're wealthy? We put real work into breaking down why these numbers exist, not just repeating them. If you value that effort, subscribe with one click and helps us keep producing content like this. One of the most revealing moments in this entire case came after the judgment when Trump tried to appeal it. In New York, appealing a civil fraud judgment isn't as simple as filing paperwork and waiting. you must post an appeal bond, usually for the full amount of the judgment. That rule exists for one reason: to prevent defendants from stalling, hiding assets, or running out the clock. And Judge Arthur Engoron made it clear this rule applies to everyone, including Donald Trump. Trump's legal team argued that posting a bond for $454 million was impossible and asked the court to reduce the amount or delay enforcement. Their pitch was essentially, this is too hard, and it would force painful financial decisions. But courts don't operate on comfort. They operate on consistency. The appeals judges weren't interested in Trump's wealth claims or political status. They focused on one question: does the law allow an exception here? The answer was no. This part of the ruling is crucial because it exposes the gap between Trump's public image and legal reality. The bond requirement didn't suddenly change because Trump was involved. It's the same rule applied to small business owners, corporations, and ordinary defendants every day. Allowing Trump to bypass it would have sent a dangerous message that wealth or power can rewrite procedural law. The court refused to do that, and here's why that refusal matters so much. Without a bond, an appeal becomes a delay tactic. With a bond, it becomes a real financial commitment. The judges made it clear that Trump could appeal, but only if he played by the same rules as everyone else. No shortcuts, no sympathy, no carve-outs. That decision alone pushed this case from courtroom drama into real-world consequences. Tell us in the comments, should the appeal process protect fairness or protect powerful people from consequences? We put a lot of effort into explaining how the legal system actually works, not how it's portrayed. If you appreciate that clarity, subscribe with one click. It helps us keep doing this work. One of the most damaging revelations in this entire saga didn't come from a judge. It came from the financial industry itself. When Trump tried to appeal the judgment, his lawyers admitted in court filings that they contacted more than 30 bonds companies, the very businesses whose job is to guarantee appeal bonds for massive judgments. And according to Trump's own legal team, every single one of them refused. Not one, not even with extra conditions, just a flat no. That matters more than almost anything else in this case. Bond companies don't care about politics. They don't care about public opinion or cable news. They care about risk, liquidity, and whether they'll get paid if the appeal fails. These companies looked at Trump's assets, his finances, the judgment, and the odds, and concluded that backing him was too risky. That's not an emotional decision. That's a cold, calculated financial judgment. Here's the contradiction that stunned the court and the public. For decades, Donald Trump has claimed to be worth billions. If that were true in a meaningful liquid sense, securing a $454 million bond should not be insurmountable. It would represent only a small fraction of his claimed wealth. But bond companies don't deal in branding. They deal in cash flow and real collateral. And what they apparently saw didn't match the image Trump spent years selling. This is why judges weren't moved by arguments about hardship. When neutral financial professionals, whose entire business depends on assessing risk unanimously, decline to get involved, it sends a powerful signal. Either the assets aren't as liquid as claimed, or the exposure is far greater than Trump admits. Either way, the refusal from 30 separate companies shattered the illusion of unlimited wealth. It wasn't the court calling Trump's bluff, it was the market. And markets don't lie to spare anyone's ego. Be honest in the comments. What does it say when 30 financial experts all walk away from the same deal? We put serious effort into connecting these dots so you can see what's really happening behind the scenes. If that matters to you, subscribe with one click. Your support keeps this channel going. At this stage, the most important thing to understand is that the state of New York isn't threatening action anymore. It has already started the enforcement process. Once the judgment was finalized, Letitia James took the next critical step, filing the judgment in Westchester County, where some of Trump's most valuable properties are located. That filing isn't symbolic. It's legal groundwork for asset seizure. Here's why that move matters so much. By filing the judgment in the county where the properties exist, the state establishes a legal claim against them. That means if Trump fails to post the appeal bond or pay the judgment, New York doesn't need to start from scratch. The paperwork is already in place. The The court can authorize the state to move forward with liens, levies, and eventual sales to satisfy the debt. This is how civil judgments are enforced every day, just rarely against someone this powerful. What makes this moment unprecedented is the scale and visibility. The properties at risk aren't small or obscure. They include high-profile real estate assets that are deeply tied to Trump's public identity and brand. Once enforcement reaches the seizure stage, the process becomes very real, very fast. Notices are issued, control changes hands. Properties can be sold under court supervision. None of that requires new findings of guilt, only non-payment. This is why judges have repeatedly rejected Trump's attempts to slow things down. From the court's perspective, the case is already decided. What's happening now is mechanical. Enforcement doesn't care about speeches, politics, or outrage. It only cares about whether the judgment has been satisfied. And because Trump hasn't secured a bond, the state is free to act. At this point, stopping the process would require money, not arguments. And that reality is what has turned this case from a legal loss into an existential threat to Trump's business empire. Comment below. Did you realize asset seizure starts with paperwork, not police showing up? We put a lot of work into explaining how enforcement actually unfolds, not just the dramatic headlines. If that clarity helps you, subscribe with one click. It keeps this channel alive. The final reason this ruling hit Trump so hard is also the most symbolic. The judge treated him like everyone else. No shortcuts, no difference, no special rules because of wealth, fame, or political power. Judge Arthur Engoron made it unmistakably clear that the courtroom is one place where status doesn't not rewrite the law. And for someone like Donald Trump, that was devastating. Throughout the case, Trump's lawyers repeatedly leaned on arguments that boiled down to exceptionalism. This is unprecedented. This is unfair. This is politically dangerous. This will harm a sitting president. But the court's response was consistent and blot. None of that changes the legal standards. Civil fraud law doesn't pause because a defendant is powerful. It doesn't soften because consequences are uncomfortable, and it doesn't bend because enforcement might look dramatic on television. What made this moment so striking is how routine the judge treated everything. There was no grandstanding in the ruling, no emotional language, just methodical findings supported by evidence followed by standard remedies. That calm procedural approach sent a powerful message. This wasn't about Trump, the political figure. It was about Trump, the business operator. And in that role, he was judged by the same rules as any other defendant who lied on financial documents. This is why Trump's reaction has been so intense. His entire public identity has been built on the idea that rules don't really apply to him, that he can pressure, delay, or overwhelm institutions into backing down. This case proved the opposite. Judges said no, appeals courts said no, and enforcement moved forward anyway. That's why this ruling matters far beyond Trump himself. It shows that when courts refuse to play favorites, the rule of law actually works even against the most powerful people in the country. Tell us in the comments, is equal treatment under the law inspiring or overdue? We put real effort into showing how accountability actually works when power meets evidence. If you want more clear, no-spin breakdowns like this, subscribe with one click. It helps us keep going.